We have to make sure early childhood education is universally provided so that we can not only ensure our kids get access to the best quality education, but that we include all our families in our community. The drivers of violence include poverty. Poverty is the cause. Poverty is what we must eliminate.
I call the Honourable Member to Iraroa Flavel. Tēnā koe.
Tēnā koe, Mr. Speaker. Malo soifua, talofalawa. Kia tātou katoa I tēnei pō. He pai nei kōrero, Mr. Speaker, pai ki te whakarongo ki ngā take ko puta mai, ko tā mātou ko te kiatu, ko wai o tēnei wharepāre ma taka whakahei te hiehie, ki te tiaki o tātou tamoriki, mai te tūkino a tētahi atu, me tere whakatika I te ture kātika. Mr. Speaker, it's unlikely that any party would oppose the concept of placing proposals to protect children from assault, neglect and ill treatment on a faster track than was originally intended. Certainly that's not what I've heard tonight. No politician, no New Zealander, I would hope, could turn a blind eye to the wicked toll on our nation with respect to the horrific situations of abuse and neglect of our children. E ai ki tā te ao Māori, he taonga te tamaiti. According to Māori thinking, at least, every child is a treasure, although sometimes we don't necessarily carry that out amongst some of our families. Every child deserves the protection of a safe home, a secure upbringing, a healthy life. And of course, it's interesting timing to be considering this bill in the wake of a report that we came across just recently. It's called Left Further Behind, How Policies Fail the Poorest Children in New Zealand. Mr. Speaker, it's important to note from the outset that this report makes it clear that while most of the discussion in New Zealand about abuse and neglect has focused on the behaviour of individual carers, a more useful discussion and analysis would consider the significance of economic, income and poverty factors alluded to by my colleague Matiria Ture. Sir, the report makes two qualifying statements. Child abuse is not limited to those on low income and those living in poverty. And secondly, that most children living in poverty and in low income households do not experience abuse. Notwithstanding this analysis, sir, the report also goes on further to explain there is an observed relationship between poverty and abuse and violence, a relationship that has obviously disastrous consequences for some of the most vulnerable children in our society. So we come to this bill which seeks to amend aspects of the Crimes Act 1961 and to protect people from assault, neglect, ill treatment, and we bring our comments to this debate with that in mind. Mr. Speaker, this bill is very much focused on the roles and responsibilities of individuals. It extends the duties of parents and those with actual care or charge of vulnerable adults and children, and it broadens the offence of ill treatment or neglect of a child or vulnerable adult. So what could we define as abuse? Well, in that regard, I come across a statement from the National Commission of Inquiry from Ingarangi, which states, sir, as a starting point, child abuse consists of anything which individuals, institutions or processes do or fail to do, which directly or indirectly harms children or damages their prospects for safe and healthy development into adulthood. I thought that was a pretty good definition. Mr. Speaker, I want to set these comments out as a context for our wider discussion in this particular bill, because I believe that we cannot restrict our response to the child abuse crisis by simply placing all of the onus on the individual in the hands of one person. All of us are implicated. It takes a village to raise a child, sir. We have supported this bill largely because the intention is for children to live in an environment free from violence, and this is consistent with umpteen traditional accounts of tikanga of the care of children from te ao Māori. The Māori Party supports at least the clause in Te Tiriti o Waitangi with respect to taonga, and of course children, and indeed all people are taonga. The protection of our most precious resource, the tangata, also underpins the values of other groups such as the Kohanga Reo movement and the Kura Kaupapa Māori movement. In this context, sir, we believe it is absolutely appropriate that children and vulnerable adults are protected from the risk of violence by a third party or the failure of the third party to perform a legal duty. But, sir, I can't sort of stand here hand on heart and say that we agree with every aspect of the bill without question. There are some issues that we did want to address. In particular, the issue that came through the select committee stage was whether we have the balance right in the introduction of liability of people, sir. The liability extends to those who are not actually involved in the mistreatment but have frequent contact with the child or vulnerable adult and fail to try to protect them from mistreatment by others. In this respect, we share the concerns of submitters around whether creating liability as the issue is the most effective course of action we can be taking to eliminate child abuse and violence against children from our lives. Surely the most searching issue for us all is how can we encourage all members of the community to create and maintain a violence-free society, sir. The bill creates a new enforceable legal responsibility, making a person criminally liable for the failure to protect a child or vulnerable person. Such an intervention was heavily criticised in some of the submissions from what I've seen, sir. The Wellington Community Law Centre was opposed to the use of criminalisation and increased penalties as a means of addressing serious social ills. In their views, the increased criminalisation of child abuse is not effective and it is an expensive response with no evidence to show that it actually works. The Whitireia Community Law Centre also considered that increased penalties for those who fulfil their legal duty to report child abuse may promote accountability but do little to assist those who are actually suffering at the hands of the abusers. In their view, government should increase funding for agencies directly connected to help those in abusive relationships, such as the Women's Refuge. Mr. Speaker, I'd be interested to hear the views of the Minister on these comments and indeed what the views of whānau, hapu and iwi are. So this whole area is highly contentious, it's complex. How do we ensure that every child is protected, every child is free from abuse? Part of the debate too brings certain assumptions to the discussion, such as that child abuse will necessarily emerge out of relationships where domestic violence occurs. And child abusers are necessarily linked to adult relationships where violence is a factor. There is the assumption that all adults are necessarily able to intervene in the ill treatment or neglect of a child, whether or not they are in a relationship, violent or otherwise. What about, sir, the situation for women who have been battered and threatened by an abuser who may not have the ability to protect the child or intervene on their behalf? These are key questions that I think need some discussion and alluded to by Materia Ture. While the legislation may provide greater ability to identify a person or persons to be held responsible for causing intentional harm and or injury of a child, we're concerned as to whether it will provide protection to adult members of the household who may also be at risk of harm and or injury. So the last thing we would want to see emerge as a result of this legislation is that more women will be arrested, charged and incarcerated for failure to protect tamariki. I want to ask the Minister for the evidence and the analysis around the phenomenon of battered woman syndrome. The Department of Corrections has a very helpful statement on the definition around battered woman syndrome, which I think bears understanding in this legislation. They describe battering as reducing the victim to a state of fear and anxiety that stretches her perception of fear beyond the time frame of violence. The relationship becomes characterised by cumulative terror because of the constant state of fear that pervades the relationship. So repeated batterings diminishes the woman's motivation to respond. She becomes passive. Her sense of emotional well-being becomes precarious. And in effect, it prevents her from perceiving and acting on opportunities to escape from the violence. What we also know is that battered women will bear the brunt of a violence in a household in their attempts to protect their children from harm. This comes through time and time again. So we seek assurances that their efforts to do so will not lead to them into a situation by which they're actually criminalised as a third party. In closing, Sir, the Māori Party is very concerned that we must take such analysis into consideration before progress can be made on this legislation, and we'll be looking to the Minister again for his advice on how such advice has shaped the bill. At this stage then, we will not oppose the bill, driven, I hope, by the need to keep all children safe, and our subsequent decisions, however, rest on how these issues are raised throughout the debate. Kia ora.
I call the honourable member